Without further ado, we're moving on to our next presentation, which is Dr. Inge Graef. So please come over. She's assistant professor at Tilburg, so people from the Netherlands are taking over this conference, and her research focus is on competition and the digital economy, and she will present a paper on algorithms and fairness and what's the role for competition law in targeting price discrimination towards end consumers. So, as always, you have 30 minutes to present, and then we'll move on to questions. And
okay, thank you for that introduction. So, indeed, my presentation will be about what could be the role for competition law in targeting price discrimination, which is not normally something that competition enforcement is about, but I think with big data analytics and algorithms making a discrimination the room for discrimination bigger, I think there should also be more reason for competition law to be more proactive in targeting these forms of exploitative abuse. So this is an example that we already also discussed yesterday. So this shows that companies are really able to do personalized pricing. So on the basis of your willingness to pay, they are able to increase the prices. So Uber, if it knows that you are from a rich neighborhood, it might increase the price to you, which is something that might not necessarily be a competition issue from the start, but it shows that these companies on the basis of data analytics are able to exploit consumer biases more effectively than ever before. So when we look at price discrimination in economics, there is a division made between three different types. So we have third-degree price discrimination, which is the form of price discrimination that is mostly regarded as not problematic. So students get discounts or pensioners. So here the supplier charges different prices to groups that you can easily distinguish from each other. Then there is second-degree price discrimination, so where a supplier offers products in different packages from which then the consumer can self-select based on their preferences. So for instance, an airline offers tickets for business travelers with some extra features, but it also offers economy class. So this is where consumers can self-select based on their preferences. But now there is also room for what we call first degree or perfect price discrimination, so where suppliers are really able to set almost exactly the price, the maximum willingness, the price that the consumer is maximum willing to pay. And in economics, generally, price discrimination is not regarded as problematic, at least as if it increases output. So the idea is that if you would have a uniform price, then consumers who might not be able to pay a product would now benefit if there is different prices set. But we also know that this higher output will increase total welfare, but it might not necessarily benefit consumer welfare. So part of the surplus of consumers might switch to the producer. Then from traditional economics, we also know that in competitive markets, price discrimination will normally lead to lower prices. So because a supplier tries to poach consumers who are more price sensitive by offering lower prices, and then this increases competition between the suppliers. But in a monopoly setting, there is indeed more room for these concerns where the consumer surplus will move to the producer. So overall, in economics, the impact of price discrimination is regarded as ambiguous, and we see also more studies now where also economists are trying to show that with these increasing forms and more perfect forms of price discrimination, it might indeed be problematic also from an economic perspective. So then if we look at the legal basis for targeting these forms of exploitative pricing on the basis of competition law, we can use the two different legal bases that we have in Article 102. So under sub A, you could see this as an unfair purchase price, but we could also rely on sub C, which is the traditional legal basis for price discrimination. But here it is clear that reference is made to trading parties. So in most cases where this provision was used, it was about downstream customers competing with one another. So so far I've only found one case where the European Commission has find a company for directly discriminating against end consumers. So then a bit about the broader perspective. So the question here is, since in a competitive market, price discrimination could also increase competition, because as long as there are no entry barriers, increased competition could also incentivize new entrants from competing in the market, and then the price discrimination would solve itself. So the market would self-correct this issue. So in a recent opinion in the Latvian copyright case, Advocate General Weil also has put this question, like, is there even any such thing as unfair prices? Because in competitive markets, there should not be a need to act because the market could self-correct these cases. Then the traditional case that we've already seen is for unfair prices is United Brands, of course, so where there are several steps that you need to follow in order to show that a price is unfair. So here it is clear that a link has to be made with the economic value of the product that is supplied, and then the excessive character of a price can either be determined by comparing the price with the production costs, which can either be unfair in itself or in comparison with competing products. Then the court has also made clear that other ways may be devised to determine whether a price is unfair. So this two-step analysis might not be the only way. The court has made clear to show that a price is unfair indeed. So one of the things that if you look at this test of United Brands from a more economic perspective is that you see that the court really puts a lot of value into comparing the price and cost. So it focuses mainly on the supply side of the market, while for economics it would normally you would also look at the demand side. So what is the consumer's willingness to pay, and how can you bring in this aspect into determining whether a price is unfair or not? And this would then also be a way to link unfair or excessive pricing with price discrimination. Then an interesting recent case was brought before the UK Competition Appeals Tribunal dealing with excessive pricing in the pharmaceutical sector, where the UK Competition and Markets Authority fined these companies for abusing their dominance, but the Court of Appeals dismissed that case. So here the Competition Authority applied a cost-plus approach, so where it made clear that you needed to look at the cost plus a reasonable rate of return, and it argued that the price in itself was unfair. But here it's interesting that the court actually relied on the opinion of the Advocate General in the Latvian copyright case, and it also made clear that it is the Competition Authority does not have a choice between either focusing on the question whether a price is unfair in itself or whether it should do a comparison with other products. But if there is methods available, then it should make sure that it tests both these limbs of the United Brands test. So another interesting aspect of this case is actually that the tribunal also made clear that here it was not sufficient for the Competition and Markets Authority to look only at the supply side of the market, but it also had to look, when determining the economic value of the pharmaceuticals in this case, also at the demand side, so at the patient benefit, which is one of the reasons why also the court dismissed the decision of the Competition Authority. So this shows that indeed also there should be more room for considering these demand side issues. So then going back to this Latvian copyright case, since this is the most recent judgment on excessive pricing, so the courts made clear that the relevant test here is that the price should be both significantly and persistently above the competitive level. So it's only in exceptional cases that competition authorities should intervene in order to address excessive pricing. And actually the opinion of the Advocate General sets out a bit more elaborately also the rationale of competition enforcement in these cases, where he also makes clear that the room for competition intervention should be limited, and there should only be room for a competition authority to intervene when it is really sure that the price difference is of such a nature that there can almost be no doubt as to the abusive nature of the price. So the more significant the difference, and also the longer the period in which this excessive pricing was sustained, in that case it should be easier for the authority to discharge its burden of proof. So this shows that indeed there is more or less consensus that the room for excessive pricing under competition, to address this under competition enforcement, is small. It should only be in exceptional cases, but still we see that also on the national level there is more cases being opened in this issue. In Italy there have been cases about excessive pricing. We'll also come back later to a competition investigation that the European Commission has opened. So while the scope is very small, I think with the changing nature of markets, it could nevertheless be that we see more situations where these high standards are met in practice. So then moving to price discrimination. So here a difference is normally made between primary and secondary line injury. Article 102C has normally been mainly applied in situations of secondary line injury, so where the effect is on the downstream customers that are competing with one another. So this is basically a form of exploitative abuse, which in the first instance might not make sense for a dominant company to do this, because the dominant company will usually benefit from having more intensive competition on the downstream level. And this is also why only in exceptional cases this provision has been used. We have already seen the wording of the provision, so you need to look at trading parties and whether they are put in a competitive disadvantage as a result of the difference in price. And this term competitive disadvantage has been interpreted differently throughout the case law. So the most recent case from 2018 in Mayo, there the court made clear that the mere presence of prices differentiation in itself does not mean that competition is distorted, but you really need to show that the customers was put in a competitive disadvantage, so that it really affected the interests of the operator who was affected by the higher price. So while normally this provision targets secondary line injuries, so exploitative abuse, we have also seen cases in the decisions of the Commission, but also court judgments where this provision was also applied to exclusionary discrimination. So this shows that this clause has been interpreted very broadly. So it might also mean that it can still also be applied in cases where end consumers are directly discriminated on the basis of price. But nevertheless, if this provision would not work out, you can obviously also link it to sub A of Article 102, which is the clause that is normally used for exploitative abuses. So here, obviously, price discrimination should not be seen unfair in itself. So if you look at a simple example, if there is two identical paintings, there are two customers on the market who each have a different willingness to pay, then actually in practice it would be instead unfair if you would apply a uniform price. So if we would use the test where the surplus should be equally divided between the consumer and the producer, then if customer 1 is willing to pay 100 euros and customer 2 1,000 euro, then if the surplus is divided equally, customer 1 would pay 50 euro and customer 2 would pay 500 euro. So if we would apply this test, then indeed price discrimination would be rather be fair in this case. Of course, the question is what test should then be applied to target price discrimination under sub A of 102. So here also the question is whether this United Brands test is still appropriate if you start from the assumption that it should only be that you should only look at the supply side of the market. So I think here also the willingness of the willingness to pay of the consumer should be taken into account. And of course also there is a need to reconcile this with the incentives to innovate and invest of suppliers. So normally in industries where there's high fixed costs, it might indeed make sense for a company to price discriminate. So this should also be taken into account. Then in digital markets specifically, I think we could ask ourselves the question whether instead of just promoting consumer welfare, whether competition law should also be concerned with protecting consumer sovereignty. So willingness to pay in digital markets might not be something that you can objectively establish. So suppliers might also use information about our preferences or behavior on online platforms in order to manipulate our willingness to pay. So in these cases, there might be more room for competition law to intervene here, not only on the basis of classic consumer welfare standard, but also on issues of consumer sovereignty, which I think need more attention, especially in digital markets, where there is simply more room for suppliers to exploit the preferences and interests of consumers. So here, a link can be made with this new investigation that was opened by the Commission in the pharmaceutical sector. So this is interesting because it's the first case where the Commission is looking into excessive pricing in pharmaceutical industry. And if you look at the press release that Commissioner Vestager made about this case, is that it's clear that she's also concerned really about the health of consumers. So not only mere economic efficiency considerations seem to play a role here, but there is also other interests that she is worried about. So this might then also be a way to apply this to digital markets, where not only economic interests should be considered, but also these interests of consumer sovereignty, for instance. So that is the part about the abuse. But of course, before we reach that stage, we also need to think of market definition and market power. And here an interesting question would be whether if you can indeed do personalized pricing, whether that then means that every consumer is a relevant market in its own. So since the supplier knows exactly what you want to pay, it can differentiate you from any other customer. So if we look at the Commission Notice on Market Definition from 1997, reference is made to the consumer, but in digital markets, and also especially when you think of services that can be targeted to the special needs of a customer, that might not be the average consumer, but every consumer should be considered separately on the basis of its own preferences and interests. And actually, it is interesting that one of the paragraphs also refers explicitly to price discrimination, where it's made clear that if you can narrow a market, so if you have distinct groups of customers, then the relevant product might constitute a narrower, distinct market when you are dealing with issues of price discrimination. So this would support the idea that if you can indeed differentiate different groups of consumers, and in the most extreme case, even one consumer from for individual consumers themselves, that they would each form a different relevant market for the purposes of competition law. The same claim can be made for market power, where if you look at the guidance paper on 102, reference is made to what is the competitive level in a market. And if you follow the same reasoning, then you could here also argue that what is the competitive price for a product is for each consumer differently, so based on the willingness to pay. So then also, if you follow that line of reasoning, you could argue that a supplier has a market power over each individual customer. So these are interesting thoughts which also raise a question of how traditional concepts of competition law can be applied to these new types of behavior. Then I would like to link these issues a bit to two ongoing policy debates that we now see at the EU level, which also kind of supports the trend that we see in competition policy discussions about broadening the objectives from simple economic efficiency considerations to also other types of concerns. There's different objectives that you could distinguish here. The more classic ones like single market, economic efficiency, consumer welfare, but we see also in recent cases and speeches of the Commissioner that also other types of objectives and considerations are gaining more importance, like fairness, non-discrimination, and also equality of opportunities. Then on the other hand, and especially when we think of digital markets, we can see that the economy is changing, so both on the demand and the supply side. So on the supply side, you could argue that algorithms and big data analytics are really changing the competitive game. Market uncertainty has always been regarded as the main driver of competition, but now you can see and monitor what your competitors are offering on the market in terms of price, but also the other parameters on which they compete. The uncertainty in the market is really decreasing. On the demand side, also we know from behavioral economics that consumers do not act rationally. So even if they are perfectly informed, there might still be room to intervene and to protect them. So this shows that since the economy is changing, we might also want to reconsider the way we apply competition law and also give more preference to other types of objectives than the traditional ones like economic efficiency and consumer welfare. Another trend is that we see more attention for principles like equality of opportunities and non-discrimination. So we discussed already the Google shopping case where the Commission imposed this principle of equal treatment on Google to make sure that it treats its own service in the same way as rival services. We've also seen this new proposal on the platform to business relations, where there is also provisions introduced about transparency regarding ranking on platforms and also transparency about differentiated treatment. At the national level, there is also initiatives ongoing. For instance, in the French Loi pour une République numérique, there is this obligation of platform fairness imposed. So we can see that these considerations are also gaining more importance. An analogy can here be made with net neutrality, so on the telecom sector, so all of these principles relate mainly to business relationships, but you might also conclude from this that also in dealings between suppliers and consumers, there should also be more room for considerations of discrimination. Then the second policy debate that is relevant here is how different regimes in EU law interact with one another. The most relevant ones would be, apart from competition law, data protection and consumer protection. And you can fit these three regimes together on the basis of the notion of choice. So here, competition law would mainly protect the availability of choice, so the fact that consumers have a choice on the market to select the product that fits best with their preferences, while data protection and consumer protection relate more to protecting the informed choice or the autonomy of consumers to make a choice. And this also shows that each of the three regimes have to be enforced coherently in order to adequately protect consumers on the market. And here you can also bring in again this notion of fairness. So fairness could here be the normative overarching principle that brings these three regimes together, because fairness plays a role in each of the three regimes. So this is probably more explicit in data protection and consumer protection than in competition law, where fairness is referenced in the two provisions, but where it's more an implicit outcome of the competitive process rather than a substantive benchmark. So in data protection, fairness plays a role in terms of the procedure, so the burden of care, for instance, that data controllers have to meet, but also substantively the fact that data controllers have to do a fair balancing of interests, so between the interest of the data subject and the legitimate interest of the data controller. So here it's really a substantive element that plays a role in how you apply these rights and obligations under data protection law. So the same you could say of consumer protection, where the Infoterms Directive refers to fairness in terms of good faith, significant imbalance, but also formal elements of fairness, like relating to transparency and information provision. And then secondly, another important instrument here is the Unfair Commercial Practices Directive, where there is 3 levels of fairness imposed. So there is a general clause, then there is a clause relating to aggressive and misleading practices, and then there is a blacklist of practices that are always regarded as unfair. So in these 2 regimes, fairness is really used as a substantive principle, while in competition law it is more an inherent objective of the field. But nevertheless, if we look at speeches of the Commissioner, we can also see that she refers more and more often to this notion of fairness. So I put 2 examples here on the slide. So competition gives consumers the power to demand a fair deal, and as competition enforcers, we should do our bit to make Europe a fairer place to live. But on the other hand, the Commissioner also made clear that there is no need to impose a new rule of fairness in our system, because fair markets are actually what competition is about. So here fairness really relates to the outcome of the competitive process rather than a substantive principle. But I think these 2 quotes also show that there is more and more awareness for how competition law should be applied alongside other regimes, so that the overall result would be a better protection of consumers. So then, following that debate, if we then look at the room for enforcing or targeting consumer price discrimination on the basis of competition law, we could also look at the remedies that are already in place in other regimes in order to, from that discussion, base our conclusion of what is the room left for competition law to possibly come up with new remedies in this regard. So in data protection, personalized pricing involves processing of data. So you also need to comply with the rules under the GDPR, where you as a data subject have a right to object to the processing of personal data for direct marketing. So if there is advertisement targeted to you, you have the right to object to that, and in that case the controller has to stop to target you. Then another relevant right here is that that you have a right as a data subject not to be subject to a decision based on automated processing which produces legal effects concerning you. So this includes forms of profiling, which would also qualify as, or personalized pricing would also qualify as a form of profiling. The catch here is that this right does not apply where you as a data subject have given your consent for these types of processing of personal data. And this is actually something new. While the Data Protection Directive did not have this option, now actually the GDPR gives more room for data controllers to do profiling. So this shows that data protection mainly relates to indeed informing data subjects and giving more transparency rather than banning certain practices. The same you could say about consumer protection, where under the Unfair Commercial Practices Directive, suppliers are basically free to set their prices as long as they are transparent about how prices are calculated. So there is here provisions about misleading and aggressive commercial practices, but personalized pricing in itself is not regarded as misleading or aggressive. If you look at guidance that the Commission adopted in 2016 on this directive, there is some examples provided where, for instance, if an airline falsely claims that there is only a few tickets left when you make your booking, that this can be regarded as a misleading practice, but then it's really that misleading aspect that is regarded as unfair or problematic rather than the personalization of prices in itself. So where personalization is combined with one of these practices, then there might be a reason to intervene on the basis of consumer protection law. Then, of course, we also have anti-discrimination law, so where differentiation on the basis of gender and racial or ethnic origin, religion, and age is prohibited. At the EU level, we also have the Services Directive that prohibits differentiation based on nationality. So there was this case against a Disneyland where only French and Belgian citizens could benefit from cheaper deals, where the Commission indeed intervened on the basis of the Services Directive to target this type of anti-discrimination. Then, of course, we have this new regulation on geo-blocking, which gives some more room to also target discrimination, but this relates more to access to websites rather than the prices themselves. So then, as a way forward, so I think it is clear that data and consumer protection should be the first line of defense here. And if consumers are indeed informed about the fact that suppliers engage in personalized pricing, this makes them already more aware, and this could also lead suppliers to abstain from these practices simply because of reputational issues. Then we have national laws that might be relevant here, EU internal market law, where certain practices are prohibited, but this scope is very limited, so it mostly relates to issues where discrimination is conducted on the basis of nationality. Then I think it's a policy issue whether there is room for competition law to intervene here. So I think this issue has not been settled. There is no, as far as I know, no court decision about whether Article 102 can also be applied in cases where final consumers are discriminated on the basis of price. But in any case, this would need to be done on a case-by-case analysis. So we know from economics that price discrimination can also be welfare enhancing. So we should make a very careful assessment of which cases would indeed benefit from a competition intervention in these cases. So to conclude, here I think because the economy is changing, also technological possibilities are changing, there is a need to revitalize exploitative abuses, also to make sure that we can follow up with firms that now have the possibility to engage in more pervasive commercial practices than before. We already see that this trend is catching on in competition policy debates, in speeches of the European Commissioner, and in practice, in order to see what scope there exactly should be for competition enforcement, I think it's important to look at how the other fields already provide for remedies in this area. That's it.
So thank you very much. Thank you very much for your presentation. We have only time for one or two interventions, which are already, well, 3 interventions because you weren't able to participate in the earlier session. So first you.
So on your first provocative question, I think my point was not that we should do only fairness under competition law. So I think indeed the most interesting cases would be where economic efficiency would clash with fairness. I think these are the cases that would require a lot of care in deciding what we should be doing then. But I think in most cases you could also see economic efficiency concerns that are then aggravated if you also factor in fairness considerations. Then on the second question, so for personalization, how should we deal with this in a world where every service or product is becoming personalized? Yeah, I don't have the answer to that. I think it's indeed very interesting, especially if you then look at how we should deal with issues like market definition and market power, because in such a world you could argue that every supplier has a dominant position over a consumer. So in that case, the scope for competition law would be much and much bigger. So I don't think that is something that we would want to go into. But I think on the other hand, now there is a need to be a bit more proactive than we have been so far. So I think you can already see that in the discussions that indeed also the Commissioner is really eager to do more on the basis of exploitative abuses. But of course the question is, where do you put the line, and where do you draw the line, and what are cases where there is really a need for an intervention?
So Michael, please.
Yeah, so on the first point, so indeed there is cases, if you look at this 102C, there are court decisions that target exclusionary behavior, but also indeed cases where it's really about downstream competitors that are, downstream customers that are competing with one another, where there is no vertical integration with the dominant firm. So as far as I know, there are no court cases about discrimination against final consumers. There is only 2 commission decisions that I know of. One was about price discrimination on the basis of nationality. So this is, I think, something that is not as controversial, because this is something that in internal market law we would be very concerned about in itself. I only know one commission decision in Deutsche Post, which was where the commission actually relied on 102C explicitly, also in a case where there was price discrimination versus end consumer. So even though that does not really follow the exact wording of the provision. Then on the second part, I think the reason why I refer to both excessive pricing and price discrimination is that since we do not have any clear precedence on what should be the legal tests for price discrimination versus end consumers, I think you could indeed make an analogy here with excessive pricing or with the United Brands case law. But I think the main point here is that in cases for price discrimination versus end consumers, you should not only look at the prices and the costs that the Court of Justice talked about, but also at the demand side, so the willingness to pay of consumers. And this could be a way to distinguish these 2 different types of abuses.
Okay. And final question, and the rest of you can discuss with me over the coffee, which we're having afterwards in Knowledge. So please, Nicola.
Yeah, so on the second point, that's indeed an interesting question, because the question would be, are those really substitutable products or services that these competing firms then offer to a consumer? And here I think maybe because it's very difficult for a consumer to find out and to compare products or services that are very personalized, maybe this is a consideration that should be taken into account, where indeed it might not be clear for a consumer, him or herself, that there is actually more choices available, since it's so difficult to compare personalized offers from different companies. And then on the point of consumer sovereignty, yeah, it's a difficult issue. So here I think competition law could play a bigger role, because yeah, it's for consumers. It might be not that clear what choices they actually have on the market, and here again this issue of manipulation could play a role. So where consumer sovereignty could also mean that consumers should be informed about the choices that they have, and it should be clear what parameters are available. So this could be a consideration that is now normally targeted under consumer protection and data protection regimes, but I think since the remedies in these regimes might not be sufficient to capture the concerns, maybe there is also room for competition law to step in here. But then indeed the question is, to what extent should we be concerned about this? So this is something that I hope to think about a bit more in the future, and hope to answer them better.